Hi everyone, Muskaan here, and in this video I'm going to be discussing the concept of condition and warranty under the Sale of Goods Act. To start with, we already know what a contract is. It's an agreement that is enforceable under the law. Now, what kind of agreement? An agreement between two or more people in order to exchange a certain object with a certain consideration. Now, the object is usually goods or services, and the consideration is usually the price of the object. Now, all contracts are dealt with under the Indian Contract Act of 1872. Initially, this concept of sale of goods specifically was covered under sections 76 to 123 of the Indian Contract Act. However, they soon realized that those sections was not enough to cover the vast amount of legal provisions that can come under sale of goods. It wasn't enough to properly take care of the sale of goods. And so in 1930 they came out with the Sale of Goods Act. This was enacted to deal specifically with the buying and selling of goods. So it covers all commercial transactions between buyers and sellers, and the object of the act is to ensure fairness and transparency when dealing with these commercial transactions. Now, while sale of goods comes under the Indian Contract Act and most definitions in sales of goods are the same as the definitions in Indian Contract Act, there are a few terms that are added on to the Sale of Goods Act, one of which is the term condition. And in this video, we're going to be looking at the meaning and the types of conditions. So let's look at the meaning and the definition of condition. Now, in layman terms, people might use condition as a general term to mean a condition for anything. But when it comes to legalese, specifically Sale of Goods Act, a condition of a contract of sale is usually the foundation on which the contract rests. That means it's the primary or the major stipulations of the contract. So if the conditions themselves are not fulfilled, then the entire contract becomes useless. The entire contract can be rendered void, it can be repudiated. Right? So if either party does not fulfill any condition, then the other party has the full right to terminate the contract completely and refuse to perform their obligations. On top of that, the injured party can also claim damages or compensation from the party that has not fulfilled the condition. Now we'll look at definition. Under the Act, the Sale of Goods Act, Section 12, subsection 2 defines a condition as a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. So, it is a stipulation that is essential to the contract. Without this stipulation, the contract would be useless, and the breach of which gives the right to treat the contract as repudiated. This means, the party who fails to adhere to a condition is considered as having repudiated the contract. Okay. Next, Section 12(4) states that in order to consider a stipulation in the contract as either a condition or a warranty, the construction of the contract should be taken into consideration. This means that in a contract, even if a stipulation is called a warranty, but the entire contract rests or hinges on the fulfillment of the stipulation, then it will still be considered as a condition because that is the meaning of the term condition. Now let's look at the types of conditions. So the first conditions conditions and warranties both actually can be broadly divided into two categories. One is express, which basically means the condition is expressly laid down in the contract. There's nothing to be implied, nothing to be assumed. In the contract, these terms are specifically laid out. Then we have what is known as implied conditions. These conditions are assumed unless and until the contract specifically states that we will not be taking this as a condition. So if the contract states that any of these implied conditions are not going to be taken as conditions, then it won't be implied. Otherwise, it will be taken as employed. And implied conditions or implied warranties are dealt with under sections 14 to 17 of the Act. The first type of implied condition is a condition as to title. This is given under section 14, and it states that it basically says that the seller should have the title to the goods, and therefore he should have a right to sell the goods. Now, obviously, if you are a seller and you're going to sell goods to me, you need to have the legal right to actually possess and sell those goods. If the goods weren't even yours to begin with and they belong to a third party, and then the third party comes up and tells me, like, how do you have that? That's not yours. Then the goods have to be returned to that party. But I can come and take compensation from you. Why? Because you sold me goods that weren't even yours in the first place. So, the first condition is that whatever goods you are selling, you have the right to sell those goods and you have a title to those goods. Secondly, we have condition as to description. This is given under section 15. What this says is the goods that are actually sold, the goods that are delivered, should match the description that has been laid down in the contract by the buyer. So if I am the seller and you are the buyer, and both of us agree on a particular type of goods that I will be selling to you, and we write it down, even if we don't write it down in the contract, but we have discussed about it, then the goods has to match the description that is being sold. Third, as to quality. Now, this is given under section 16. What does this state? This states that this means the quality of the goods should be fit for the purpose needed by the buyer, and it should be of mercantile quality. Purpose needed by the buyer just means that whatever the purpose the buyer needs it for, obviously the goods has to be able to match that purpose. And most often, most of the time, people have discussed, the buyer and the seller discuss why this buyer needs the goods, and so that is one of the implied conditions. The second one is that it needs to be of mercantile quality. What does mercantile quality mean? This is basically referring to a minimum quality of the goods, so that such that even a reasonable person should be able to look at the goods and realize the goods are of a good quality. And finally, we have condition as to sale by sample. What does sale by sample mean? This happens when between a buyer and a seller, if this seller first gives a small quantity of the goods to the buyer inspects that sample of goods given, and then based on the quality of the samples or the description of the samples, he then decides to order more, and then he gives an order for a larger number of that particular goods. So when it comes to sale by sample, obviously the goods first of all have to be of mercantile quality. They should be of reasonable quality, and they should match the quality and description of the sample itself. Now, if I'm selling you a large number of something and you have taken a sample from me, and based on the quality and the description of the sample, you say, yes, okay, now you can give me 200 more of that. And the 200 more I sent do not match what I have already given you. Then again, that is not allowed. That will be considered a breach of the essential condition of the contract, and the contract will then be repudiated. Okay, so now we've finished what the term condition means. Let's move on to what the term warranty means. Now let's look at the meaning and the definition of the term warranty. A warranty is basically an additional stipulation that is laid down by either of the parties, and this is usually over and above the conditions that are already framed. So in other words, a warranty is basically the secondary terms of a contract. It's not the primary terms, it's the secondary terms. And because it's the secondary terms, a failure to meet the warranty does not cause the repudiation of the entire contract. So just because the warranty is not matched does not mean the entire contract becomes useless. The sale of goods can still take place even if a warranty has been breached, because it does not form the basis of the contract. However, while the injured party does not have any rights to terminate the entire contract, and they still have to fulfill their obligations, but they can approach the court to claim their damages, their compensation, or whatever else it is in respect of the breach of warranty. Now, definition is given under section 12(3). A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not a right to reject the goods and treat the contract as repudiated. So, this means that as long as the main conditions are fulfilled, the contract cannot be repudiated. If the collateral conditions, the warranty is not fulfilled or the warranty is breached, what does collateral mean? It's a secondary term. Then you can claim for damages, but you cannot reject or the contract entirely. And as always, we have to remember the fact that in order to consider a stipulation in the contract as either a condition or a warranty, the construction of the contract should be taken into consideration. This means that even if something has been called a condition, but it is very obviously secondary in terms of the contract, then it will be considered as a condition, as a warranty itself. Also, there are certain times when a condition can be treated as a warranty. We'll look into that in a later slide. Alright, now let's deal with the types of warranties. Similar to conditions, the two main broad types of warranties are express, in which the warranty is expressly laid down in the contract, and implied, which is basically assumed warranty. It will be assumed as a warranty unless and until stated otherwise in the contract. The first type of implied warranty is warranty as to undisturbed possession, given under section 14. This is the counterpart to the condition as to title given under section 14. So, while a seller must have a title to the goods and must have the right to sell the goods, similarly, a buyer must be able to enjoy quiet and uninterrupted possession of the goods. Nobody should be coming in and claiming that the goods are theirs and things like that. So, however, this is still considered a warranty and not a condition. Why? Because there may be instances where the buyer has the right to the goods, but somebody else is creating an issue. Now, the seller may have a right to sell the goods, but somebody else is creating an issue. So, this is not entirely the seller's fault, and while the buyer will still be compensated for it, he cannot simply repudiate the contract for it. Secondly, we have warranty as to freedom from encumbrances. This means the goods purchased by the buyer must be free of any extra charge or encumbrance in favor of a third party. If there is a loan, if there is a mortgage for the goods that the buyer does not know of, then it will be considered a breach of warranty. Now, it is only when the buyer is not aware of this fact. Say you have bought the goods being entirely aware of the fact that there is some extra charge on the goods, then it will not be considered as a breach of warranty whatsoever. Finally, we have a warranty to disclose dangerous nature of the goods. What does this mean? So, if the goods have some inherent dangerous quality, or if you know that there are such kind of goods that may be dangerous in the future, then this person who is selling the goods must inform the buyer of this fact. The buyer should be informed that the goods are dangerous. Of course, this should be informed to the buyer only if he doesn't know. If the buyer already knows or should already know about it, then it's a different situation. But if the buyer does not know about it and you have not informed the buyer about it, then it will be considered a breach of warranty. Okay, so like I mentioned earlier, there are situations where a condition becomes a warranty. A condition of a contract, the primary term is suddenly treated as a secondary term, and it will not lead to a repudiation. So this is given under section 13, where a condition may be treated as a warranty when number one, the buyer decides to continue the contract without terminating it. So what does this mean? This means that a condition has been breached, but the buyer decides to still continue with the contract. He does not want to terminate the contract. So he waives his right to terminate the contract, and he waives the condition itself. He might say that fulfill the condition or fulfill something similar to the condition, but he is still ready to go ahead with the contract. Another way he can do this is, say for example, there is a breach of condition and the buyer goes to the court, and instead of asking for termination of the contract, instead of asking for treating it as a breach of contract, he treats it as a breach of warranty and only asks for damages. Then in that situation, a condition will then be treated by a warranty. The second way is if the buyer accepts all the goods in a contract where it is which is not severable. What does severable mean? It means the goods cannot be separated. So if the goods can be separated and the buyer only takes those goods which he wants to take and not the goods which he doesn't want to take, then it's totally fine. That is, the condition will not be treated as a warranty. However, if the contract is not severable and the buyer accepts all the goods, even though there has been a breach of condition, then also it will be treated as a warranty. He can ask for compensation, he can ask for damages, but he cannot terminate the contract once he has accepted all the goods. So, to conclude, we know that in every contract of sale, there are certain specifications or stipulations of a contract that are put forth by each of the parties involved, and this conditions, warranties, stipulations deal with the description of the goods, the type of goods, the quantity and the quality of the goods, how the goods will be delivered, and so on. Now, all of these will be classified into either conditions or warranties. Conditions are essential, they're the foundation of the contract, and if the condition is not followed, the contract is treated as repudiated and the other party can terminate the contract. Secondly, there are warranties, which are secondary terms and which are collateral to the main terms. And if they are breached, then the other party can claim compensation, but they cannot terminate the contract. So it is very important to be able to identify which are conditions and which are warranties in order for the parties to protect their own rights and ensure that the other party fulfills its obligations. I hope this video has cleared up the concept of condition and warranty, because this basis is very important to understand the rest of the Sale of Goods Act. So thank you so much for watching. Please like and subscribe, and I'll see you next time.